Welcome everyone to this evening's panel discussion. The Montana Constitution celebrates 50 years. Your right to vote, save it or lose it. This program is co-sponsored by the Montana League of Women Voters, Helena Chapter, and the Lewis and Clark Library. This is part of a series of events the League of Women Voters is holding this year to mark the Montana Constitution's 50th anniversary. Tonight, our panelists are voting rights experts who will speak on protecting Montanans' right to vote, threats to Montanans' right to vote, and what you can do about it. The speakers will specifically address current legal challenges to laws passed by the 2021 Montana legislature that ended same-day voter registration, prevent ballot collecting, restrict political campaign activities on campuses, and changes to voter ID laws. The format is as follows. Each speaker will present his topic for about 10 minutes, and then we will have a Q&A at the end. You can post your questions in the chat. We do ask that if you have a specific person you want to answer your question, go ahead and put that part in your chat question. This program is being recorded and will be posted on the Lewis and Clark Library's YouTube channel. Tonight's four speakers have extensive and varied expertise on voting rights and will address current threats in Montana. Our speakers are Dr. Jeremy Johnson from the Carroll College Political Science Department, Mike Malloy from Malloy Law Firm, Alex Raitt from ACLU Montana, and Keaton Sunchild from Western Native Voice. Our first speaker is Jeremy Johnson, and he is, as I said, the chair of the Political Science and International Relations at Carroll College, specializing in American politics. He is also the director of Carroll's Constitutional Studies program. A frequent commentator on Montana politics, he earned his master's and PhD from Brown University and his BA from the University of Pennsylvania. The topic of his talk is Your Right to Vote as Provided by the Montana Constitution. Thank you.
Thank you very much. Thank you for having me here tonight. I really appreciate the opportunity to be able to speak to all of you. Just as Suzanne said, I was asked to provide some historical context and about the Montana Constitution in regards to voting rights before we get to our three lawyers talking about the current challenges. Now, some background. As early as the 1860s, we already were drafting a constitution in Montana. We were still a territory. That one got lost at the printers. However, the first constitution that actually got passed when we became a state was in 1889. And that constitution was in effect for the rest of the 1800s until the 1900s, until the early 1970s. A convention passed it, dominated by famous copper king, William Clark, notorious for greasing the political system with money. The state constitution that came out in 1889 was criticized heavily for benefiting corporations such as the Anaconda Copper Company, and was not noted for protecting the rights and needs of the citizens of the state. Organizations, especially the League of Women Voters, studied the problems inherent with the old Constitution from 1889 and came to the conclusion it was hopelessly inadequate to meet the needs of Montana in the late 20th century into the 21st century. So League members were active in 1971 in studying these issues that were involved in drafting the Constitution. And then in 1972, League members testified numerous times at the Constitutional Convention and sent many letters supporting the new Constitution. League members went door to door to explain why friends and neighbors should vote yes for the Constitution that came out of that convention in the 1972 referendum. The League worked very hard to encourage Montana voters to ratify the Constitution in 1972. And they have continued to believe it's definitely worth defending, as we're now at the 50th anniversary of the passage of the Montana Constitution. One of the very special parts of holding the Constitutional Convention in 1972 was that instead of having legislators rewrite the Constitution, regular Montanans were elected to the convention, and they took their work very seriously. One aspect of that work, of what the Constitution aimed to address and improve on, was concerns about voting and elections, as they were still following, in many cases, the original design from the 1889 Constitution. There was general agreement that the new Montana Constitution should, I'm quoting directly from the transcripts of the 1972 Constitution, adopt the aim of making the electoral process as effective and meaningful as possible for the individual Montanan. The delegates at the Constitutional Convention hope to bring the new state constitution into compliance with the US Constitution, federal statutes on voting, and as well as to encourage and expand citizen participation in the electoral process in Montana. A committee was formed at the convention that was called the General Government and Amendment Committee, which reviewed elections and suffrage. There was agreement that the inherited 1889 Constitution was lackluster in fulfilling any sort of modern mission to maintain elections and suffrage. For instance, that original Constitution extended voting disenfranchisement to felons even after they were released from prison, an issue which the committee thought imperative to change with the new Constitution. Quoting the committee report at the convention, the presumption is that when a man comes out of prison, he should be encouraged to resume normal civic relationships. Another example was that the old Constitution provided an exclusion for voting with quote, on sound mind. The committee thought it unwise to freeze arbitrary mental disqualifications into a constitution. They want to eliminate that sort of language. Also, a one-year residency requirement to live in Montana as part of the old Constitution, which at that point was not even being followed in the state, was also eliminated from the new Constitution. The committee, and then more broadly, all the delegates at the Constitutional Convention, did not always concur specifically on every detail about how to make elections more effective and meaningful, but there was agreement that elections had to be more election and meaningful. For instance, there was disagreement about the role of registration of voters and whether poll booth registration, which means that was the language used, same day of voting registration, should be put right into the Constitution or not. It was pointed out in the debates that the main purpose for registration laws was to prevent voting fraud. Yet, it was pointed out by delegates at the convention that in states like North Dakota, which allowed poll booth registration, that fraud was virtually non-existent. Some discussion and some debates have not changed completely over 50 years. Some things are still being talked about in similar terms. In the end, the delegates at the convention included in the Montana Constitution, Article 2, the Declaration of Rights. Section 13, the right of suffrage. All elections shall be free and open, and no power, civil or military, shall at any time interfere to prevent the free exercise of the right of suffrage. It was clear from that language in the Montana Constitution where the delegates stood about elections and encouraging free and open elections. Clearly, the constitutional language reflects a public spiritedness that was consistent with the general ethos that permeated the entire Constitutional Convention. And it was decided, unlike what was written in the 1889 document, to avoid including too many specific details and allow the legislature to work out some of the specifics while hopefully remaining true to the openness animating the Constitutional Convention. The Constitution was then ratified by the voters in Montana in 1972. Consistent with the desire that the Constitution serve the will of the people and to encourage community engagement, the Constitution mandated that the citizens vote once every 20 years on whether to hold a new constitutional convention. Again, this reflects the importance to the delegates of the democratic and public accountability and citizen engagement that we should all have for our Constitution. In 1990, Montana voters overwhelmingly chose not to hold a new convention. And again, in 2010, they chose, but by a narrow margin, not to hold the Constitutional Convention. Therefore, our Constitution from 1972 remains intact. Despite the intent of the delegates at the Constitutional Convention and the language included in the document, the implementation and protection of voting rights have been far from ideal. For example, in Native American communities and reservations, we have seen litigation over voting issues over the past decade. Now, very recently, a new specter has emerged, which puts the expansive view of suffrage as exemplified by the views held by the delegates of the Constitution in jeopardy. There is a fundamental political pushback attempting to roll back voting rights, which strikes at the heart of healthy democratic values in Montana. Some of the lawyers on this panel will discuss these current challenges. It is not easy to meet this current crisis without a demand from the citizenry that voting rights must be protected and seen as a duty for good citizenship. Grassroots mobilization supporting voting rights has never been as strong in Montana as, say, in the South, with the legacy of the civil rights movements in the middle of the 20th century. Nonetheless, as a community, we must again rally to protect voting access and the right to the ballot, to preserve the values we hold dear in the state of Montana, just as the delegates to the Constitutional Convention had done so 50 years ago. Thank you very much.
Thank you, Dr. Johnson. Next, we have Mike Malloy. And Mike Malloy is a Helena-based trial practice attorney focusing on constitutional issues. He operates the Freedom of Information Hotline and was active in drafting, enacting, and implementing legislation for the right to know provision of the Montana Constitution. He is a former Montana legislator who also taught constitutional law at Carroll College. The topic of his talk is voting rights on trial. Thank you, Mike.
Hello, everyone. My name is Mike Malloy. I am here to talk to you tonight about the involvement I've had in enforcing the right of suffrage, or the right to vote, as Dr. Johnson pointed out in the beginning of his presentation. In the heart of the pandemic in 2020, Governor Bullock issued an executive order which allowed voting counties to have the 2020 election by absentee ballot. President Trump's campaign sued Governor Bullock in the state of Montana, claiming that because there was such widespread voter fraud in Montana, that we really needed to cast our vote in person. And this again, right in the heart of the worst part of the pandemic. The case was filed in federal court in Missoula. The federal court held a hearing, and after the hearing was completed, made a very specific finding that election fraud allegations made by the Trump campaign was a fiction, and that there was no evidence of any voter fraud in Montana in any election in the last 20 years. He denied their request for an injunction, and the 2020 election went on primarily by absentee ballot, almost completely by absentee ballot. And we had the largest voter turnout in 50 years. For some reason, still boggles my mind, the Montana legislature came back some 6 months later and enacted a spate of restrictions on voter access, and I want to talk about that. One of those, among those bills was House Bill 176 that prohibited people from registering to vote on election day. And this was a change that we've enjoyed in Montana for a number of years, that people who, for whatever reason, need to register to vote on election day can do so. House Bill 176 prohibits that. Second bill that was passed by the Montana legislature, House Bill 169. House Bill 169 prohibited a student from using their student ID as a method of identifying themselves when they presented themselves to the polls to vote. The legislature also reenacted the House Bill 530, which imposed restrictions on who and under what circumstances people could help other people get their absentee ballots to the election administrator. This was essentially a reenactment of a piece of legislation that a district court in Yellowstone County had struck down 2 years before. The Montana legislature also passed Senate Bill 319, which restricts political committees from being involved in voter identification and get out the vote efforts in campus facilities on the university, on the Montana University system. The House Bill 176, 169, and 530 were challenged by a number of groups in state court in Yellowstone County. Senate Bill 513, the restriction on campus was challenged in federal court in Missoula. We had an argument on a hearing on our case in Yellowstone County, beginning of the month, March 10th. Alex Raitt, who spoke for Western Native Voice and ACLU, did an awesome job in persuading the judge down there to issue a preliminary injunction so that we could stop these restrictions from being effectuated on the June 7th primary. Judge hasn't ruled on our motion yet, and has set a trial date for June 20th, in which we will have a trial on whether or not to make an injunction effective as to the November election. These bills may seem to you to be individually not so significant, but when they're taken together, the impact of these pieces of legislation severely restrict people with disabilities, people who have trouble getting to the poll, the elderly, Native Americans, low-income people, working class people. They have a fairly profound effect as a group on the right to vote. And we're hoping that we'll be successful in challenging these legislation, this very restrictive legislation, come June 20th in state court in Yellowstone County, and essentially enforce the constitutional right that Montanans have to exercise their voting rights. That's all I had.
Thank you, Mike. Our third presenter is Alex Raitt from ACLU Montana. Alex is the legal director at ACLU of Montana and has been involved in numerous legal challenges to laws restricting voting rights in Montana. The topic of his talk is impacts of voting restrictions on Indigenous communities. Thank you, Alex.
Thanks, Suzanne, and good evening, everybody. Thanks for the invitation to visit with you all tonight. It's an honor to be here with some of the esteemed panelists. Mike and Dr. Johnson certainly are more steeped in voting rights than I am. I'm very much a jack of all trades, master of none at the ACLU Montana. We litigate across the board on civil liberties and social justice issues. And I've only relatively recently come to the table on voting rights litigation. Yeah, what I wanted to focus on primarily was the impact of voting restrictions on Indigenous communities in Montana. But before I do that, I just wanted to note that I think that litigation is an imperfect tool to expand the franchise in Montana and across the country. Really, the important work is being done by Keaton over at Western Native Voice, by Legal Women Voters, by Montana Conservation Voters, by the parties in getting out the vote and getting people to the polls, because that's really the only way that we're going to continue to expand the franchise is by, making sure that people are using any and all means that they can to cast a ballot. Unfortunately, where legislatures, or the Congress is enacting voting restrictions, sometimes the last resort is to challenge those voting restrictions in the courts. And specifically with regard to Indigenous voting issues, it's an unfortunate reality that disenfranchising Native American voters is the natural outflow of the colonization and genocide that is the hallmark of the United States of America. It was only in 1924 that Indigenous people in the United States were actually allowed access to the franchise. And over the course of subsequent to 1924, there have been numerous attempts to continue to disenfranchise and dilute the voting power of Native Americans, both in Montana and across the country. So litigation has been one way that Indigenous communities have been able to fight back. In 1986, the ACLU represented an individual on the Crow Reservation in the Windy Boy versus Bighorn County case that established voting districts in the school board and the county commission that resulted for the first time ever in Bighorn County, a county, of course, which encompasses the Crow Reservation, in electing a Native American county commissioner. More recently, in the early 2012, 2013, 2014, I had the privilege of being involved with the wandering medicine case. And this is a good example of, for once, an effort to expand the franchise via litigation. And the point of the wandering medicine case was to establish what we call satellite voting locations on Native American reservations in Montana. And this is a through line that you see with a lot of the litigation that has been brought on behalf and by Indigenous communities. And that is that there are unique challenges that are faced by Native American voters who live oftentimes in very remote, geographically isolated areas, who face significant socioeconomic obstacles, who lack residential mail delivery, and who face discrimination, hostility, and violence when they travel to border towns in order to cast their ballot. And in the wandering medicine case, what we were trying to do was to use the Voting Rights Act, which is a piece of federal legislation, to ensure that Native American voters could cast their ballot at a elections office that was actually on the reservation. And that meant that they didn't have to travel 50 miles in crappy November Montana weather to cast their ballot in a racially hostile border town. It meant that they could go to the seat of their tribal government and cast their ballot there. Now, while that case ultimately resulted in a settlement, I would say that it was probably one of the low points of my legal career, insofar as we mediated that case with a federal magistrate, and ultimately the settlement agreement that was reached was that a satellite voting location on the impacted reservations would be open 2 out of 5 days. And from our client's perspective, and this is an incredibly valid perspective, that's a pretty bad 2/5 compromise. There's no reason why those offices should not be open 5 days of the week during the entire portion of the early voting period. So, but nevertheless, as a result of that wandering medicine settlement, there have been in every election since satellite voting locations established on reservations across the state of Montana for both the primary and general statewide elections. Now, that's not to say that the counties who ultimately administer elections have not, jumped up and down and said, hell yeah, we're going to do this. We've had to oftentimes drag them kicking and screaming along the way. I was just looking through my files, and I think in every election that during my tenure as legal director for the ACLU of Montana, I've had to send out numerous demand letters to county elections officials and county commissions saying, this is the law of the land. You need to establish these satellite voting locations. And even as recently as the last election, we had to actually file a lawsuit against Pend Oreille County because they refused to establish a satellite voting location on the Blackfeet Reservation. So following the Wandering Medicine case, there were some interesting developments in the federal law that essentially gutted the primary tool for protecting the franchise in federal courts, and that's the Voting Rights Act, and in particular, the Section 2 of the Voting Rights Act. So with the rightward tilt of the U.S. Supreme Court, that has meant that that Section 2 of the Voting Rights Act has no longer, or is not as viable a tool for protecting the franchise for marginalized communities and voters. And that has very much meant that we have refocused and redoubled our efforts in state court, relying upon our very vibrant, as Dr. Johnson described, state constitution. And the right to vote is contained in our Declaration of Rights, has been deemed a fundamental right, is subject to what we call strict scrutiny, which means that a restriction on voting can only pass muster if the state demonstrates a very important, compelling state interest. And so our efforts have been focused almost exclusively in state court, relying upon our state constitutional provisions. And as Mike mentioned, that was most recently manifested in a challenge to the Ballot Interference Prevention Act, which was enacted by voter referendum in 2018, in which we successfully challenged in 2020 on behalf of 5 tribal governments, Western Native Voice and Montana Native Vote, which, as you'll hear from Keaton, are 2 Indigenous-led voting rights organizations here in Montana. And then, just this year, as Mike noted, the numerous restrictions that were passed by the legislature are being challenged by a number of parties, including Montana Youth Action, the Montana Democratic Party, and then some tribal governments, and again, Western Native Voice and Montana Native Vote. And I just want to turn to the state interests that the Secretary of State continues to throw out there to the courts, justifying these restrictions, for example, on ballot collection or on eliminating election day registration. And what they are arguing is insidious. They are saying that even if there is no voter fraud in Montana, even if they can't prove that one person has been prosecuted under the existing anti-fraud statutes in Montana, of which there are many, nevertheless, the fear that elections are insecure justifies passing voter restrictions. So think about what that means. In the wake of the 2020 election, there is the big lie that has been propagated that somehow the election was stolen. That big lie has, according to the state, caused an enormous decline in voter confidence in the integrity of our system, which has then precipitated additional and provided the justification for additional restrictions on voting. It is a self-perpetuating cycle that is designed to disenfranchise voters across the state of Montana. There is no other reason. And behind that veneer, behind that patina of justification that the state offers, is a more insidious motive. And that's simply to disenfranchise certain segments of the voting population. And in particular, Indigenous voters who already face significant challenges to accessing the franchise. That sort of narrative, the big lie, is something that has infected the Secretary of State's briefing on these issues. It has provided the justification and the rationale that they're advancing to district court judges, both in federal court and now in state court, and is merely subterfuge for preventing swaths of the public from voting. And as Mike noted, the irony, of course, is that in 2020, there was a Republican thumping that occurred with enormous voter turnout. And yet the state legislature has decided that certain segments of the voting public are not worthy and should be disenfranchised as a result. So voting rights in Montana are at risk, and they will continue to be at risk given the current political climate. But in particular, the rights of Indigenous folks in Montana, and in particular, Indigenous folks living on rural reservations, are under enormous jeopardy and risk. And unfortunately, sometimes the only way that we can push back against that is via litigation. And we should all be grateful and sing a love song to our modern Constitution and the district courts and the Montana Supreme Court, which has jealously guarded those protections that are contained in our Declaration of Rights. And as long as those protections are there and the courts are available, and courageous clients like Western Native Voice are ready to stand up, we'll be right there with them. Thank you.
Thank you, Alex. Our final presenter is Keaton Sunchild with Western Native Voice. Keaton has been active to ensure Native Americans have a voice in politics and was hired in the fall of 2020 as the political director for Western Native Voice. In 2018, Keaton ran for office as a senior in high school to help ensure that Native Americans would have a voice, especially in his generation. He has been involved in various political campaigns for the last 2 years. He is committed to all Native Americans to ensure that their concerns are heard, their stories are shared, and that they get the representation that they deserve. The topic of his talk is the history of Native vote and the voting rights barriers that they faced historically and continue to face even now. Thank you, Keaton. Welcome.
Thank you, guys. Thanks, everybody, for tuning in. Thank you. Thank you to the presenters before, and especially to Alex for bringing shedding continued light on a lot of the barriers that Native American voters face in Montana. Typically, our presentation on this centers a lot on the things that Alex went over, but luckily for all of you, or unlucky, depending on how you look at it, we have two. So I will kind of go over the history up to the point of what Alex just went over, and then there'll be a little bit of overlap, but not a lot, and then we'll go from there. But something that early American colonists, and then certainly as the founding fathers were kind of coming to different conclusions on how the new American government should be set up, a lot of the founding fathers looked at the Native American tribes' governmental, for lack of a better term, structures. As that the time that America was forming our government, the Native American tribes before and through the Revolutionary War had very sophisticated, popularly based, and well-developed methods of organizing their societies and tribes. And while Europeans labored under authoritarian and hierarchical, I can never say that one, governments, most American tribes were democratic and representative governments, similar to what America has now. Lots of tribes were what we now consider forward thinking in the idea that they had universal suffrage for men and women. They had provisions for recall, or what are now modern day recall elections, referendums, other modern political practices and processes that are now kind of attributed to American and European political theories and theorists, but were actually kind of set up by many Native American tribes early on. And like I kind of touched on, a lot of the framers borrowed these ideas and concepts. Benjamin Franklin visited the Iroquois nation because they were considered one of the most foremost tribal structures in the Washington, D.C. area. I'm actually in Washington, D.C. right now for work, and there's a lot of Iroquois influence around here, especially as you walk kind of through the mall area. And we were in the Capitol earlier, and there's several references to the Iroquois nation kind of sprinkled throughout the Capitol. But along with Benjamin Franklin, James Madison, James Monroe, and Thomas Jefferson all made visits to the Iroquois. And it was Franklin who kind of remarked that the organization of what the Iroquois called the League of the Iroquois, and that later turned into the Iroquois Confederacy, said that the colonists should imitate the structure that they had set up. And that he thought that was kind of the path that the American colonies should kind of set themselves out on. And obviously they ended up taking parts of it, but they did not mimic it entirely. And a lot of that had to do with the early relationships that the European settlers, the new American colonists had with a lot of the Native American tribes in the area. The relationships were complex, contentious at times, sometimes collaborative. There was a lot of fighting over access to land and resources. As the United States moved further west, military alliances were formed, trade was conducted. And there's early founding father writings and teachings that they did kind of admit that the idea and the experiment of self-government was practiced by Native Americans before the formation of the formal U.S. government. And now we kind of look at that, especially at Western Native Voice, with all the lawsuits that we've been involved in. I mean, this is my second one, and I've been with the organization for just over a year now. It's been a year and a half. Just over a year and a half now. But I've already been involved in 2 lawsuits. So, there's an idea out there that Native Americans were, practicing self-government long before the idea of self-government, but yet they're still constantly fighting for the legal protections in this self-government system. And in the original language of the Constitution, you won't really find mentioning of Native Americans having the exclusive right to vote. In the 14th Amendment, which Alex briefly touched on earlier, and specifically the Equal Protection Clause, that kind of serves as the basis for all federal voting rights laws. And it sort of prohibits specific limitations and discriminations in voting. The Constitution also sets out, this is the federal Constitution, but the state Constitution has a similar clause to Article 1, Section 2, Clause 1 of the U.S. Constitution. The Montana Constitution closely follows that section, in that who gets the right to vote in Montana has to obviously fit into Article 1, Section 2. But the leaving out of Native Americans in the early drafting of the Constitution has kind of given the relationship between, has kind of forced the relationship between Native voters and the federal government and the state level government into a unique relationship. And as states began to grant the right to vote in 1924 through the Snyder Act, states didn't have to immediately, the Snyder Act wasn't signed into law and the next morning Native Americans were not granted the right to vote. It wasn't until almost 40 years for all 50 states to allow the Native Americans the right to vote. Maine was one of the last states in the late 60s, 1965, I believe it was, 65. So, that's not that long ago that every Native American didn't have the right to vote. Montana was kind of right in the middle. We were in the late 20s, more on the early end in terms of if you're looking at that whole 40-year gap. But there were a number of states before us. But Maine is an interesting kind of case study because Montana still struggles with, even now, last legislative session, there were a number of representatives who pointed out that the Montana Constitution says that it gives special protections to taxpayers. They're not special protections, but there's special provisions in there laid out for taxpayers, and they tried to use some piecemealed argument that because Native Americans, and this was a falsely concocted argument, but they said that because Native Americans didn't pay taxes, which is not true, they shouldn't be allowed to vote under the Montana Constitution, which is similar to something a former state senator in Maine said, just saying that Native Americans have never been voters. They're not smart enough to be voters. They don't, they didn't do anything to earn the right to vote. And that's kind of a similar take we had here in Montana. When it was when amendments were being passed in the state legislature in the 30s, there were still laws that we saw in the Jim Crow South, literacy tests, voter ID or poll taxes. We saw more recently issues with voter ID laws. And we're still seeing those now, as Alex mentioned. But it wasn't until that 72 convention here in Montana that all of that kind of went away. The literacy tests, the poll taxes. For a long time, a lot of Native elders didn't understand what was on the ballot. They literally could not read it because it was not in their traditional language, and they weren't allowed to have like translators or material like instructions written in their native languages or traditional languages. So now that's part of the reason we see sometimes now it's more prevalent in like Hispanic districts. You'll see sometimes the ballot instructions written in different languages, but that was originally, especially in Montana, passed because there was a provision in our Constitution that made that legal to have those instructions written in a different language. But a lot of the argument in Montana that was made to kind of expand the voter rights for Native Americans was a lot of Native Americans served in World War II, especially here in Montana. Close to 30% of the men who had served in World War II were Native Americans. So they figured that was kind of turned the argument of, well, they haven't done anything to earn the right to vote to rest. They went and fought for America overseas. And that kind of spurred things along. But then there were several Native Americans in other states who returned from World War II and were denied the right to vote. And it wasn't until there were two states left in 1948, New Mexico and Maine. And then in 1948, New Mexico, borrowing from Montana, Idaho, and one of the Dakotas, I can't remember off the top of my head, finally removed the provisions in its state constitution that kept Native Americans from voting. And then in turn, Montana used that similar provision in the language that came in New Mexico's constitution to write the part of the Montana Constitution that got rid of a lot of these restrictions. that were in place. And then in 1965, after the Voting Rights Act passed on a federal level, that just kind of reaffirmed and added voting rights protections and kind of eliminated the idea of lawsuits for the voting rights provisions that have been put into Montana law up to that point, specifically in regards to Native Americans, which sort of cleared the way then 7 years later in 72 for the Constitution to have a lot of the protections that it has now. And then Alex kind of touched on a lot of the court cases that were important. And I'll just kind of skip through to kind of where we are today in terms of voting rights and the Montana Constitution. Obviously, there were a number of legally questionable and challengeable laws that were passed last legislative session. A lot of them both being challenged, in regards to the federal Constitution and then, of course, to the state Constitution as well. Something that was important to our members is, being able to keep voting with their tribal IDs. For a lot of folks, that's the only access to an affordable form of ID that they have. And so for them to be able to continue to vote and to register to vote with just a tribal ID was hugely important, or is hugely important. And it's still something that is making its way through the courts right now. And then, Alex said it too. So did a couple of the earlier presenters. This is kind of a constant cycle where we see these laws, we go to litigation, they tweak one thing, and we go back again. I said it earlier, this is my second one in 18 months. And so, that now it's to the point where it's built into our budget almost, where, okay, well, we're probably going to have to go to court for at least one thing. So let's just go ahead and build it. And when I build my political program at the beginning of the year for the next year, so at the end of 2021, when I was starting to build for 2022, a lot of it was, okay, well, we're going to need to collect certain data for lawsuits that are going to come as a result of the 2023 legislative session. So that's where we're at. Good or bad, that's the state of voting rights for Native Americans here in Montana.
Thank you, Keaton. This was very interesting and informative. Now we'll have a question and answer session. We already have a couple of questions in the chat. So if our panelists want to go ahead and turn on your cameras again. Our first one is, do the new laws that limit voting rights in Montana benefit one political party over another? And I'll just let whoever wants to take it, go ahead and raise your hand or start talking, and we'll just kind of open it up. Jeremy, yes.
Sure. Well, a couple of our panelists have already pointed out there's sort of a paradox there when we look at the 2020 election, that when you have more expansive access to the polls in the state of Montana, it actually benefited, apparently in 2020, Republican candidates. However, we've seen as the Republican Party that has generally, that is a Republican Party that wants to limit access to the polls, and obviously when you have targeted groups that might be more Democrat, that might be more Democratic leaning constituencies, they might be adversely affected by some of these new laws. Certainly, there's a nationwide thing. It's a nation. Montana is one place of a nationwide efforts of what's being made. So, but yeah, so that's sort of my take on it. I just think that when we had a very widespread voting, it did not hurt Republicans, it actually helped Republicans. However, generally we often see targets to students, et cetera, they might be overall more Democratic. So those groups could be hurt.
Thank you. And that kind of segues into the second question. With respect to not recognizing student IDs when voting and to banning political groups from doing voter registration on campuses, it's clear the intent is to make it hard for young, more liberal voters from voting. But how does the Secretary of State make the argument that these laws have anything to do with voter security?
Well, we're waiting to hear. We're waiting to hear about that. I don't think that any of these recently enacted pieces of legislation do anything to address even perceived voter integrity issues. So it's like, if voter fraud or problems with voting is a fiction, as the federal judge ruled, then it just doesn't make any sense that we should be enacting further restrictions in order to, I guess, make the system more pure. And the problem with all of that is that these restrictions impact a very narrow, as Professor Johnson said, that very narrow group of people. I don't know whether they're Democrats or Republicans, but I can tell you that those disadvantaged people need someone to stand up for them, and that's what we've been doing.
Thank you. Our next question is, acknowledging that it is difficult to prove a negative, how do the panelists think our government can best demonstrate, monitor, or prove on a continuing basis the small amount of voter irregularities that could silence the repeated claims asserting significant voter fraud? I'm going to read that again. Acknowledging that it is difficult to prove a negative, how do our panelists think our government can best demonstrate, monitor, or prove on a continuing basis the small amount of voter irregularities that could silence the repeated claims asserting significant voter fraud?
I wouldn't even begin to take a run at that question. I don't really understand it. Sorry.
Yeah, and I would just note as well that, I mean, these claims about voter fraud and as a justification for the various laws that are being enacted are bogus, in part because we have existing anti-intimidation statutes, anti-fraud statutes. I mean, there are laws on the books that make it illegal to, for example, sign somebody else's name on a ballot or to intimidate somebody into voting a particular way. So these really are, you know, a problem in search of a solution, or a solution in search of a problem, rather. And you know, as the question notes, it's difficult to prove a negative, but there really is no valid justification that has been offered, at least as far as I've seen, in front of a judge to justify these laws. Now, of course, the court of public opinion is very different, and that's where we're seeing you know, these widespread claims, these disinformation campaigns that in theory are justifying these laws, but every single time they come before a court of law where the burden of proof is clear, they fail to meet that burden.
Thank you. Our next question, they're coming fast and furious, guys. So thank you for spending your time answering these questions. Our audience is very engaged, so this is exciting. Our next question asks, mail-in ballots are generally sent out 3 weeks before an election. How does Montana law address the issue of mail-in ballots to young people who don't turn 18 until the ballots are sent out, but before the election date?
Mike, you want to take that one?
Yeah, I can. I think Montana permits people who are going to turn 18 before the election and therefore entitled to vote to pre-register. The problem is that House Bill 506, which is one of these pieces of legislation that was passed in this last session, changed the method of of sending out those absentee ballots until after the voter turned 18. So the voter used to be able to get a ballot ahead of the election by pre-registering, and then could vote it once he turned 18, he or she turned 18. Now that can't happen. You have to wait until you're 18 before you even get the ballot. Was there another hook on the question that I missed? Was that the question?
Hang on. I think that was the question. Yes, that was the question.
Okay.
Jeremy. All right. Our next question is, are there any statistics on how many people were turned away from registering and voting in our last election?
I haven't seen any statistics. I mean, in part, and I'm assuming that the question is related to voting restrictions that were enacted, but in part because we successfully challenged the Ballot Interference Prevention Act in advance of the 2020 election. So that particular restriction didn't exist at that time. We do know, so since the election day registration was eliminated, there were some county and municipal elections in 2021, in November of 2021. And we have heard from elections administrators that there were individuals who showed up to register on election day who were turned away. Those elections, the county and municipal elections, obviously have much lower turnout than we would expect to see from a statewide election. And so I think it's fair to say that if election day registration remains or is eliminated in 2022, you could see, potentially thousands of votes being thrown out.
Thank you. And this question, I may have missed it, but are tribal IDs not valid IDs for voting?
Keaton, you want to take that one?
Yeah, I can take that one. Yes. So they are valid for voting. So like you can use it as a valid ID to vote, but registering to vote with the law, one of the laws that passed in 2021, they would not be in itself enough to register. It would need to be supplemented by another form of ID. But I believe that bill is also being challenged in court. So to vote, yes. To register, yes, but you need to supplement it with like a bank statement, W-2, something else that you might have lying around.
Thank you. Next question, has a money pathway been discovered that is paying for this nationwide effort to nitpick away various voting rights in so many states? Who is paying for what appears to be a coordinated effort to suppress votes nationwide?
I'll take a cut at this. There are, I don't believe it's just one organization, but you're quite right. There are multiple organizations, at least from what I understand, some of them which have been operating for decades, which have some of these agendas. They're often financed by very, very wealthy individuals with agendas, and sometimes corporations as well. And so this and some other issues. So I don't have the, sometimes it's also hard to sometimes track exactly how the money flows, what the names of the organizations are. So there's, but certainly there are coordinated moneyed efforts to do some of these type of things. Certainly there's been accusations at times, the American Legislative Exchange Council, among other groups, potentially, possibly, have had interest in seeing some of these efforts done. However, I don't have right here for you, I can't sort of track all the specific details and the names of all the organizations and exactly how all this has focused and where we stand right today. But there is money behind this.
Thank you, Jeremy. Does anybody else want to talk about that? All right, next question. Mike indicates that the court may decide on the case against several of the 2021 voting bills in June. If the court rules against these laws, is the state likely to appeal to the Montana Supreme Court? When would the Montana Supreme Court likely hear these cases? Would it be likely that the ultimate decisions won't be reached before the 2022 November general election?
We've scheduled these cases, believe it or not, with some cooperation from the Secretary of State, so that we get a ruling even from our Supreme Court before the November election, sufficiently in advance of the November election, so that if we prevail, those restrictions will not be enforced. Election day registration, for example, is not elimination of election day registration isn't effective until election day. So if I think we'll be able to get a ruling from the Supreme Court, regardless of which way the district court goes, in time to have a successful election, one way or the other.
The other thing I'll just add on that
Yeah,
point is that one of it's very likely, in fact, probably 100% certain that the voting cases and the voting challenges will go up to the Montana Supreme Court. And what the state is arguing, they're very much presenting a appellate argument in district court. They're saying that an entirely different standard for reviewing a fundamental constitutional right, the right to suffrage, the right to vote, should be applied in the context of these challenges. They're saying that some federal case law should control the way that the courts view the right to vote. And that's a really dangerous argument to make, not just in the context of voting rights, but in the context of all of the fundamental rights that are contained in Article 2 of our Constitution. Because if indeed we're going to carve out perhaps the most fundamental right that's important to the vitality of our democracy, which is the right to vote, for a different and lower standard that federal courts have used, then what's next? I mean, are we talking about all of the other rights that are contained in our Constitution, from the right to privacy to the right to freedom of religion, for a different standard? And it's notable that our Supreme Court for decades now has really taken great care to differentiate between the way that it interprets our state constitution from the federal analogs in the federal Constitution. And so what the state is advocating is a very dangerous, slippery slope, and what could lead to an erosion of all of the rights contained in Article 2 of the Constitution.
Thank you. And we have one more question, and I would love to hear from everybody. So short, I know we're almost out of time. A short answer from everyone, but how can we as Montana voters help protect our right to vote? Jeremy, let's start with you. What are your thoughts on that one?
We have to have public discourse. People talk about these issues in the newspapers, not just a small group of people, but we have to have, I mentioned grassroots mobilization, find ways to have grassroots mobilization, again, in Montana. There's different ways it can take, but it takes, public demand and public attention and public caring.
Thank you. Alex, how about you?
Yeah, I mean, I think I started out my segment just by talking about how litigation is an imperfect tool for achieving full and fair access to the franchise. I really think that the things that people can do to protect our right to vote is to support the organizations that are going out and getting people to the polls and getting out the vote. And that is the Western Native Voices of the world. Those are the tribal governments of the world. In certain respects, those are the parties. But the more our voices are heard, the more, we're going to have free and unfettered access to the franchise. I mean, this goes to an earlier question around which party these particular restrictions are intended to benefit. it really doesn't matter. If what matters to you is your ability to cast your ballot and your neighbor to cast their ballot, then we need to be organizing communities and making sure that that public demand and that public support for the franchise is being voiced with a full throat.
And Keaton, how about you?
I think the easiest way to protect it is to do it. You vote, and there's a lot of laws. Like I just told our members on a membership conference a little over a week ago that we were talking about the congressional map for the 2 new congressional seats, and a lot of them were voicing their displeasure, feeling like the native vote was kind of being silenced. But just reminded them that if every eligible native voter comes out to vote, it really doesn't matter what the district lines look like. So I think that kind of goes for everybody. If you vote, then you never know what can happen. And right now our turnout numbers aren't where they should be. So if everybody brings 3 people to vote with them, then those numbers will get up to a good spot.
Thank you. And Mike, what are your thoughts?
Stand up for the truth. Don't let your legislators get away with the argument that we have voter fraud, widespread voter fraud in Montana, and therefore we need these restrictions. That's a fiction, and we should not let people get away with that. And the bottom line is to dispel the big lie.
Thank you. And I do have one more thing to share. This is a list of other organizations that are helping with your right to vote. The Montana League of Women Voters, the Montana Secretary of State Election and Voter Services has information, and opensecrets.org. I would like to thank our panelists for your wonderful presentations tonight. Thank you for your time, and thank you very much to our audience, and have a good night, everybody. Thank you very much.